Hello and welcome to Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Don't forget to like, subscribe, and click the notification bell if you like our content. Let's jump right into it and hit question number 1. Okay, question number 1. Let's ensure that we get off on a great foot. Let's make sure we get this right. Question number 1. In 1970, Oscar, owner of a 100-acre tract, prepared and duly recorded a subdivision plan called Happy Acres. The plan showed 90 1-acre lots and a 10-acre tract in the center that was designated Future Public School. Oscar published and distributed a brochure promoting Happy Acres, which emphasized the proximity of the lots to the school property and indicated potential tax savings because the school district will not have to expend tax money to acquire this property. There's no specific statute concerning the dedication of school sites. Oscar sold 50 of the lots to individual purchasers. Each deed referred to the recorded plan and also contained the following clause: no mobile home shall be erected on any lot within Happy Acres. Sarah was one of the original purchasers from Oscar. In 1976, Oscar sold the remaining 40 lots and the 10-acre tract to Max by a deed which referred to the plan and contained the restriction relating to mobile homes. Max sold the 40 lots to individual purchasers and the 10-acre tract to Pete. None of the deeds from Max referred to the plan or contained any reference to mobile homes. Assume for this question only that Pete has announced his intention of erecting a fast food restaurant on the 10-acre tract and that Sarah has filed an action to enjoin Pete. If Sarah wins, it'll be because, let's look at our 4 options. A, Sarah has an equitable servitude concerning the use of the tract. B, Sarah as a taxpayer has legal interest in the use of the tract. C, Sarah is a creditor beneficiary of Oscar's promise with respect to the tract. Or D, Pete is not a bona fide purchaser. Take a few seconds and choose what you think is the best option for an answer here. I hope you chose option A. Sarah has an equitable servitude concerning the use of the tract. Remember, an equitable servitude is a promise concerning the land that binds the original parties and their successors. The burden in an equitable servitude will run with the land if the following elements are met: if there is a writing, if there's an intent of the original parties, and touch and concern the land, and there is actual notice. Here, the Happy Acre subdivision plan designated the center tract as Future Public School. The deed Oscar sold to Sarah referred to this recorded plan. The center tract restrictions run with the land because otherwise Pete's restaurant could be built on the center tract, prohibiting the school from being built. The covenant touched and concerned the land because it dealt with the legal relation of parties as owners of lots in Happy Acres. While Pete did not have actual notice of the restriction, Pete had recorded notice because the restriction was in the chain of title and the subdivision plan was duly recorded. As a result, he is implied to have had knowledge of this. These facts establish that Sarah likely has an equitable servitude concerning the use of the tract of land, which would provide a basis for her to win in her action to enjoin Pete from building a restaurant on that tract of land that was earmarked for a school, or building a restaurant which would then permit the school to not be built. Therefore, if Sarah wins, it'll be because Sarah has an equitable servitude concerning the use of the tract of land. Let's look at the other 3 options and see why they're not as correct, or in some senses completely incorrect. B, Sarah as a taxpayer. We can stop right there. Everything you've read to this date should let you know that generally there is no such thing as taxpayer standing. So Sarah as a taxpayer, done. End of story. Don't have to read anything else. It's over. B's not an option. C, Sarah as a creditor beneficiary of Oscar's promise with respect to the tract. With respect to C, Sarah, as the creditor-beneficiary, the creditor-beneficiary relationship is simply not an appropriate description, so it doesn't fit the scenario. D, Pete is not a bona fide purchaser. There's nothing in the facts that leads us to believe that this is true. In fact, there's nothing in the facts that lead us to believe in any direction. So as a result, B, C, and D should all be eliminated right off the top of your head, and A should be the only option, because at the end of the day, the equitable servitude arises out of the fact that there was the promise made within the contracts which were duly recorded. Question number 2, Harry met Bill, not Sally, who was known to him to be a burglar, in a bar. Harry told Bill that he needed money. He promised to pay Bill $500 if Bill would go to Harry's house the following night and take some silverware. Harry explained to Bill that, although the silverware was legally his wife would object to his selling it. Harry pointed out his home, one of a group of similar tract houses. He drew a floor plan of the house that showed the location of the silverware. Harry said that his wife usually took several sleeping pills before retiring and that he would make sure that she took them the next night. He promised to leave a window unlocked. Everything went according to plan, except that Bill, deceived by the similarity of the tract houses, went to the wrong house. He found the window, unlocked, climbed in, and found silverware where Harry had indicated. He took the silver to the cocktail lounge where the payoff was to take place. At that point, police arrested the two men. If Harry were charged with burglary, his best argument for acquittal would be that A, there was no breaking, B, he consented to the entry, C, no overt act was committed by him, or D, there was no intent to commit a felony. Take a few seconds and choose what you think is the best option now. I hope you chose option D. There was no intent to commit a felony. The common law elements of burglary are trespassory breaking and entering into the dwelling of another at night with the specific intent to commit a felony or larceny inside. Larceny is the wrongful taking and carrying away of another's tangible, personal property without consent and with the intent to permanently deprive that person of this property. In this case, Harry did not intend to have Bill wrongfully take another person's silverware or otherwise commit a felony inside his house. Rather, Harry intended Bill take Harry's own silverware out of Harry's own house. There cannot be burglary without the requisite specific intent to commit a felony or a larceny inside of a dwelling. Thus, Harry's best argument for acquittal would be that there was no intent to commit a felony. Let's take a look at the other options and see why they're not as correct. Now, let's think through what the scenario here in fact was. Harry, the homeowner, that's why they obviously have him starting with an H. It's amazing how the bar puts these things together. But Harry, the homeowner, intends for Bill, the burglar, again, it's funny how they start with the same letter. Harry, the homeowner, intends for Bill, the burglar, to come into his own home and take his own property. So as a result, there can be no implied or transferred intent that Harry intended for there to be any form of burglary as a result of the fact that Bill was in essence taking Harry's own property with consent. So once we look at the facts in that way, in analyzing the other options, we see why they're not as correct as D is. A, there was no breaking. Is there really an issue? First of all, was there a question of there not being any breaking? There is breaking, because regardless of the fact, Bill the burglar did in fact enter. He crossed the threshold into this other tract house that wasn't in fact Harry's house. So that is factually incorrect. There was a breaking. Bill the burglar entered into someone else's home. So A is factually eliminated. B, he consented to the entry. Now, that's a bit tricky because there was a consent to an entry, but there was a consent to an entry to Harry's home, not to this other third person. Let's call him Terry because he's Terry tract homeowner, right? Terry did not consent to having his home or her home entered. So the consent is in fact actually invalid. So even if there were consent, and here there was, Harry granted consent to have his home entered, the consent to the other third person is irrelevant because Harry has no rights to that third person's home. C, no overt act was committed by him. That may be irrelevant because if he in fact planned and participated in the crime, he might be equally as guilty on an accomplice basis or some other similar basis. That being said, the reality here is that the very best option as a defense is there was no intent to commit a felony. There was no intent to commit a crime in essence. Well, not this crime, perhaps some other crime, but not the intent to commit a crime of burglary of any way, shape, or form. More so, it seems like there was just simply an attempt to secure some funds through an insurance claim or some other. It's unclear to the facts. We can only assume. But lying to your wife, unfortunately, doesn't rise to the level of criminality. We all know that it probably should, but unfortunately it doesn't. So as a result, option D is your very best option here. Okay, let's move on to question number 3. I know you've got a great winning streak going. Let's keep it alive. Question number 3. Betty Bauer, an adult, asked Jeff Geddes to lend her $1,000. Geddes replied that he would do so only if Bauer's father, Cash, would guarantee the loan. At Bauer's request, Cash mailed a signed letter to Geddes. If you lend $1,000 to my daughter, I will repay it if she doesn't. On September 15th, Geddes, having read Cash's letter, lent $1,000 to Bauer, which Bauer agreed to repay in installments of $100 plus accrued interest on the last day of each month beginning October 31st. Cash died on September 16th. Later that same day, unaware of Cash's death, Geddes mailed a letter to Cash advising that he had made the $1,000 loan to Bauer on September 15th. Bauer did not pay the installments due on October 31st, November 30th, or December 31st, and has informed Geddes that she will be unable to make repayments in the foreseeable future. For this question only, assume that Bauer's entire $1,000 debt is due and that she has failed to repay any part of it. In an action by Geddes against Cash's estate for the $1,000 plus accrued interest, which of the following, if any, will serve as an effective defense for Cash's estate? 1. There was no consideration to support Cash's promise because he did not receive any benefit. 2. Cash died before Geddes accepted the offer. Or 3. Cash died before Geddes notified him that his offer had been accepted. Now, look at your options. A would be 1 only, B is 2 only, C is 1 and 3 only, and D is neither 1 nor 2 nor 3, so none of the above. Take a few seconds and choose what you think is the best option as an answer to this question. The best answer here is D, neither 1, 2, or 3, or none of the above. A unilateral contract is where the offer expressly demands acceptance by performance. Consideration is the bargain for exchange between the parties. Consideration is present anytime promises with value or performances are exchanged. Any legal detriment or forbearance, as well as actual benefits and performance, can constitute consideration. In this case, Cash's promise was supported by consideration. Cash does not need to receive the benefit in order for his promise to be supported by consideration, as long as the benefit Cash bargained for was rendered to someone. Cash's offer was a unilateral contract because he was inviting Geddes' acceptance by performance. When Geddes loaned Bauer the money, the day before Cash died, Geddes accepted Cash's offer. Notice of acceptance is not necessary in a unilateral contract because acceptance occurs through the actual performance. Thus, neither 1, 2, nor 3 are effective defenses for Cash's estate. Let's take a little bit of analysis and see if we can address why 1, 2, and 3 would not be appropriate defenses. So, option number one, there was no consideration to support Cash's promise because he did not receive any benefit. Let's think that through a little bit. His daughter was loaned money. In all likelihood, if she hadn't received that loan, the funds probably would have come from him otherwise. So there is some benefit here. And more importantly, someone received a benefit. He signed off ensuring that someone else received a benefit. So in essence, he was a co-signer. So if co-signers are not held responsible in any way, shape, or form, I am not certain how well our financial institutions will do. However, let's look at option number two. Cash died before Gitas accepted his offer. That's actually, unfortunately, inaccurate. The money was loaned before the death. And given that this was a performance contract, that means the contract was accepted at that very moment when the funds were loaned. So as a result, 1 and 2 thus far are simply factually incorrect. 3, Cash died before Gitas notified him that his offer had been accepted. It's not required that he notify the other party. So because as we just noted, the acceptance is completed once the funds are loaned on this type of contract. So again, equally 3 is simply invalid. So without question, D, neither 1, 2, nor 3 is the only acceptable answer here. Question number 4. In 1970, Oscar, owner of a 100-acre tract, prepared and duly recorded a subdivision plan called Happy Acres. Hello again, Happy Acres. The plan showed 90 1-acre lots and a 10-acre tract in the center that was designated future public school. Oscar published and distributed a brochure promoting Happy Acres, which emphasized the proximity of the lots to the school property and indicated potential tax savings because the school district will not have to expend tax money to acquire this property. There's no specific statute concerning the dedication of school sites. Oscar sold 50 of the lots to individual purchasers. Each deed referred to the recorded plan and also contained the following clause. No mobile home shall be erected on any lot within Happy Acres. Sarah was one of the original purchasers from Oscar. In 1976, Oscar sold the remaining 40 lots, the 10-acre tract to Max by a deed which referred to the plan and contained the restriction relating to mobile homes. Max sold 40 lots to individual purchasers and the 10-acre tract to Pete. None of the deeds from Max referred to the plan or contained any reference to mobile homes. Assume for this question only that Joe, who purchased his lot from Max, has placed a mobile home on it, and that Sarah brings an action against Joe to force him to remove it. The result of this action will be in favor of A, Sarah, because the restrictive covenant in her deed runs with the land. B, Sarah, because the presence of the mobile home may adversely affect the market value of her land. C, Joe, because his deed did not contain the restrictive covenant. Or D, Joe, because he is not a direct but a remote grantee of Oscar. Take a few seconds and choose what you think is the best option now. Four for 4. Come on, let's do it. The correct answer is A, Sarah, because the restrictive covenant in her deed runs with the land. A covenant is a contractual limitation related to land, distinguished from an easement, which is a grant of a property interest. A negative or restrictive covenant is a promise not to do something related to the land. The burden in a restrictive covenant will run with the land if the following elements are met. If there's a writing, there's an intent of the original parties, if it touches and concerns the land, if there's horizontal and vertical privity, and notice. Here, the Happy Acres subdivision plan designated the center tract as future public school. The deeds Oscar sold referred to the plan and contained the restriction relating to mobile homes. This restriction runs with the land because otherwise a mobile home could be built on the center tract, prohibiting the school from being built. The covenant touched and concerned the land because it dealt with the legal relation of parties as owners of lots in Happy Acres. While Joe did not have actual notice of the restriction, Joe had record notice because the restriction was in the chain of title and the subdivision plan was in fact duly recorded. Therefore, the action will result in favor of Sarah because the restrictive covenant in her deed runs with the land. Let's look at options B through D and discuss why they're not as accurate. B, Sarah, because the presence of the mobile home may adversely affect the market value of her property. Now, that being said, that's not necessarily the best or even a potential route for standing, because the other individual, if there is no contractual restriction, has every right to enjoy their land so long as they're doing so legally. So B may not be a very good answer. C, Joe, because his deed did not contain the restrictive covenant. While that's true, Joe's deed did not contain the restrictive covenant. What we're looking at is the chain of custody and the chain of the title. That restrictive limitation or the restricted language was clearly in prior titles, and it carries with the land. It doesn't dissipate simply because it's simply forgotten to be included in the next iteration of the deed. Or D, Joe, because he is not a direct but a remote grantee of Oscar. Not sure that's relevant because, again, the restrictions run with the land, not with the knowledge of the parties, but with the land, especially if, and as noted under the requirements, especially if there's notice. If notice is recorded, it's a dead issue. The restriction runs with the land. Question number 5. Harry met Bill, who was known to him to be a burglar, in a bar. Harry told Bill that he needed money. He promised to pay Bill $500 if Bill would go to Harry's house the following night and take some silverware. Harry explained to Bill that although the silverware was legally his wife would object to his selling it. Harry pointed out his home, one of the group of similar tract houses. He drew a floor plan of the house that showed the location of the silverware. Harry said that his wife usually took several sleeping pills before retiring, and that he would make sure that she took them the next night. He promised to leave a window unlocked. Everything went according to plan, except that Bill, deceived by the similarity of the tract houses, went to the wrong house. He found the window unlocked, climbed in, and found silverware where Harry had indicated. He took the silver to the cocktail lounge where the payoff was to take place. At that point, police arrested the two men. Bill's best argument for acquittal of burglary is that he, A, acted under a mistake of law, B, had the consent of the owner, C, reasonably thought he was in Harry's house, or D, found the window unlocked. Take a few seconds and see if you can choose the best answer here. Well, I hope you got this one right, because this was a straightforward one. Not too tricky here. C, reasonably thought he was in Harry's house. Remember, the common law elements of burglary are trespassatory, breaking and entering into the dwelling of another at night with the specific intent to commit a felony or larceny inside. To satisfy the element of trespassatory breaking and entering, an obstruction to entrance must be overcome. Answer choice C is clearly Bill's best argument for acquittal of burglary, because if Bill thought he was in Harry's house, he would not have satisfied the fourth element of burglary, that the defendant must have the specific intent to commit a felony or larceny inside. Of course, there is no felony or a larceny if Harry, in fact, had consented to the taking. Then there, in fact, actually is no fourth element here, or trespassatory taking. Let's look at the other options. A, acted under a mistake of law. Mistake is generally not a protection or a defense, especially in criminal matters. B, had the consent of the owner. He did not have the consent of the owner because he broke into Terry's house, as we noted, not Harry's house. He made a mistake and entered into a third person's home. D, found the window unlocked. Now, the window being unlocked is not necessarily beneficial here. Remember, there has to be some sort of obstacle, some sort of something. The window being unlocked doesn't specify the window is open. Secondarily, it doesn't specify that there's a consent to enter or permission to enter simply because a window is unlocked or even open. And you could argue that there is, in essence, a threshold around the home, that entering that border, going through that border, is at that point in and of itself a trespassory breaking and entering into the property. That being said, the reality is that the best defense here is one that addresses the issue of intent. He did not intend to commit a crime. As a matter of fact, he intended to enter into a property that he had every permission to enter into. He intended to take property that he had every permission to take. He was given specific instructions on where the items were, and he took nothing else other than what he was instructed to take. So as a result, C would be the best answer here. Okay, let's hit question number 6. Toon Corporation, a radio manufacturer, and Bill's Comics Incorporated, a retailer, after extensive negotiations, entered into a final written agreement in which Toon agreed to sell and Bill's agreed to buy all of its requirements of radios, estimated at about 20 units per month, during the period January 1st, 1988 and December 31st, 1990, at a price of $50 per unit. A dispute arose in late December of 1990 when Bill's returned 25 undefective radios to Toon for full credit after Toon had refused to extend a contract for a second 3-year period. In an action by Toon against Bill's for damages due to the return of the 25 radios, Toon introduces the written agreement which expressly permitted the buyer to return defective radios for credit, but was silent as to the return of undefective radios for credit. Bill's seeks to introduce evidence that during the 3 years of the agreement, it had returned, for various reasons, 125 undefective radios, for which Toon had granted him full credit. Toon objects to the admissibility of this evidence. The trial court will probably rule that the evidence proffered by Bill's is A, inadmissible because the evidence is barred by the parole evidence rule, B, inadmissible because the express terms of the agreement control when those terms are inconsistent with the course of performance, or C, admissible because the evidence supports an agreement that is not within the relevant statute of frauds, or finally D, admissible because course of performance evidence, when available, is considered the best indication of what the parties intended the writing to mean. Take a few seconds and choose what you think is the best answer now. If you chose option D, you'd be correct. Admissible because course of performance evidence, when available, is considered the very best indication of what the parties intended the writing to mean. The parole evidence rule states that no prior expressions, written or oral, or contemporaneous oral statements are admissible that contradict the final integration between the parties. Course of performance evidence is admissible to clarify ambiguous terms in a contract. In this case, the Toon Bill's contract was ambiguous as to whether undefective radios could be returned for credit. During Bill's course of performance for the 3 years, Bill's returned 125 undefective radios for which Toon had granted him full credit. This course of performance evidence demonstrating Toon's acceptance of the undefective radios in exchange for credit is probably admissible to establish that the parties intended for the undefective radios to be returned for credit. Therefore, the trial court will probably rule that the evidence proffered by Bill's is admissible because course of performance evidence, when available, is considered the very best indication of what the parties intended the writing to mean. Let's look at the other 3 options and see why they're not as viable. A, inadmissible because the evidence is barred by the parole evidence rule. Well, we have an inherent problem here. Remember that what the language of the parole evidence states, which is that no prior expressions, written or oral, or contemporaneous oral statements are admissible that contradict the final integration between the parties. Here, we're talking about behavior subsequent to the contract. So does it even fall into the parole evidence rule? Does it even fall into the limitations we're discussed here? My presentation would be that it doesn't, and I'd say that A should be removable as an option. B, Inadmissible because the express terms of the agreement control when those terms are inconsistent with the course of the performance. I'm not exactly sure what that means. I'll be very honest with you, but let's analyze a bit further and see if we can clarify. B, inadmissible because the express terms of the agreement, so the agreement itself, controls when those terms are inconsistent with the course of performance. So basically it says it's fine, it's inadmissible because the agreement says it's inadmissible. It doesn't. Silent to it. That's actually the entirety of the issue. It's silent as to whether the undefective radios can be returned. So B is not a very fair representation of what the facts nor what the best option would be here. Or C, admissible because the evidence supports an agreement that is not within the relevant statute of frauds. The main issue here is that it's simply missing the point. At the end of the day, what we're looking at is the performance and what was the actual performance. How does the performance define what the parties intended the agreement to mean? As a result, without question, D is by far the more superior answer here. Question number 7. In 1970, Oscar, owner of a 100-acre tract of land, prepared and duly recorded a subdivision plan called Happy Acres. Here we go. Once again, third time's a charm. Happy Acres. The plan showed 90 1-acre lots and a 10-acre tract in the center that was designated future public school. Oscar published and distributed a brochure promoting Happy Acres, which emphasized the proximity of the lots to the school property and indicated potential tax savings because the school district will not have to expend tax money to acquire this property. There's no specific statute concerning the dedication of school sites. Oscar sold 50 of the lots to individual purchaser. Each deed referred to the recorded plan and also contained the following clause. No mobile home shall be erected on any lot within Happy Acres. Sarah was one of the original purchasers from Oscar. In 1976, Oscar sold the remaining 40 lots and the 10-acre tract to Max by a deed which referred to the plan and contained the restrictions relating to mobile homes. Max then sold the 40 lots to individual purchasers and the 10-acre tract to Pete. None of the deeds from Max referred to the plan or contained any reference to mobile homes. Assume for this question only that in 1977 the school board of the district in which Happy Acres is situated has voted to erect a new school on the 10-acre tract. In an appropriate action between the school board and Pete to determine title, the result will be in favor of A, Pete, because the school board has been guilty of laches. B, Pete, because his deed did not refer to the subdivision plan. C, the school board, because Pete had constructive notice of the proposed use of the tract. Or D, the school board, because there has been a dedication and acceptance of the tract. Take a few seconds, choose your best answer. The best answer here is option D, the school board, because there has been a dedication and acceptance of the tract. Remember that common law dedication states that when the owner of land voluntarily donates property to public use, and this donation is in fact accepted, ownership is thereby transferred to the governing body. Under the doctrine of common law dedication, no particular formality is necessary to dedicate lands, so long as there is an offer of dedication by the owner and an acceptance of the offer by the public or its representatives. In this case, Oscar prepared and duly recorded a subdivision plan where he voluntarily donated a 10-acre tract in the center for future public school. Since the school board accepted Oscar's donation, title in this 10-acre tract has passed to the school board under the doctrine of common law dedication. As such, in an action between the school board and Pete to determine title, the result will be in favor of the school board. Let's look at the other three options and see why they're not viable. Option A has this keyword laches. Laches is not generally something that's used nor presented as a defense. Generally, you can assume that's for the most part wrong. So A, we can in essence eliminate right off the bat because it's addressing, in essence, something rather ancient. B, Pete, because his deed did not refer to the subdivision plan. Not certain that that's relevant because there had already been a dedication from Oscar, who initially granted the land, and it was subsequently purchased with proper notice because this donation or dedication was properly recorded. C, the school board, because Pete had constructive notice of the proposed use of the land. The constructive notice is not sufficient. Having constructive notice is a very different animal than D, which states that the school board, because there's been a dedication and an acceptance of the tract, which in essence creates a contractual relationship. So C is simply not as good an answer as D. D, without question, is the very best response to this query. Question number 8. We're back to Harry and Bill. Hi, guys. Harry met Bill, who was known to him to be a burglar, in a bar. Harry told Bill that he needed money. He promised to pay Bill $500 if Bill would go to Harry's house the following night and take some silverware. Harry explained to Bill that although the silverware was legally his wife would object to his selling it. Harry pointed out his home, one of a group of similar tract houses. He drew a floor plan of the house that showed the location of the silverware. Harry said that his wife usually took several sleeping pills before retiring, and that he would make sure that she took them the next night. He promised to leave a window unlocked. Everything went according to plan, except that Bill, deceived by the similarity of the tract houses, went to the wrong house. He found the window unlocked, climbed in, and found silver where Harry had indicated. He took the silver to the cocktail lounge where the payoff was to take place. At that point, police arrested the two men. If Harry and Bill are charged with a conspiracy to commit burglary, their best argument for acquittal is that A, Bill was the alter ego of Harry. B, they did not intend to commit burglary. C, there was no overt act. Or D, there was no agreement. Take a few seconds and choose what you believe to be the very best answer now. If you chose option B, good for you. That's the right answer here. They did not intend to commit burglary. As we previously discussed, remember the mens rea aspect, or the intent. Here, a conviction of conspiracy requires proof of an agreement to commit a crime, and in some jurisdictions, under some statutes, proof of an overt act in furtherance of that agreement. In this case, Harry promised to pay Bill $500 to go to Harry's own house and take some silverware that legally belonged to Harry. Since a person cannot steal something that is legally his, Harry and Bill's very best argument for acquittal on the conspiracy charge is that they did not intend to commit a burglary. Do we have to analyze the other options here? We really shouldn't have to, but let's do it nonetheless. A, Bill was the alter ego of Harry. That's a very valid defense. Could he be conspiring with himself? I would argue that that's probably very unlikely. He wouldn't be able to conspire with himself. That being said, it very well may be likely that if he himself went to take his own silverware, then he clearly had no intent to commit any crime. C, there was no overt act. There was an overt act here, and this is obviously factually inaccurate, because Bill, in fact, went into someone's home. He went into the home with the intention to commit the act that he and Harry originally agreed upon. D, there was no agreement. There clearly was an agreement because the parties spoke. Bill acted accordingly and then met Harry to complete the exchange. So without question, B would be your very best defense here. The fact that they intended to commit no burglary because the items which Bill would have picked up were Harry's already. Question number 9. On March 1st, Zeller orally agreed to sell his land, homestead, to buyer for $46,000. To be paid on March 31st, buyer orally agreed to pay $25,000 of the purchase price to Quincy in satisfaction of a debt which Zeller said he had promised to pay Quincy. On March 10th, buyer dictated the agreement to his secretary, but omitted all reference to the payment of the $25,000 to Quincy. In typing the agreement, the secretary mistakenly typed in $45,000 rather than the $46,000 as the purchase price. Neither buyer nor seller carefully read the writing before signing it on March 15th. Neither noticed the error in price, and neither raised any questions concerning omission of the payment to Quincy. In an action by Quincy against buyer for $25,000, which of the following is or are correct? 1. Buyer could successfully raise the statute of frauds as a defense because the buyer-seller agreement was to answer for the debt of another. 2. Buyer could successfully raise the statute of frauds as a defense because the buyer-seller agreement was for the sale of an interest in land. Now, A is option 1 only, B is option 2 only, C is both options, and D is neither option. Which do you believe to be the very best answer? Take a few seconds and select one now. I hope you chose option D, neither 1 nor 2. The following contracts fall within the statute of frauds. Contracts incapable of being performed within 1 year, sale of goods for more than $500 or $500 or more, promises made in consideration of marriage, guarantee to pay the debts of another, executor promise to pay estate debts with own funds, and transfers of interests in real estate. In this case, the contract between seller and buyer for the purchase of homestead is a transfer of an interest in real estate. So this contract must be in writing. However, this contract is in writing, so that is not the issue here. The issue here is the oral agreement between seller and buyer that buyer pay $25,000 of the purchase price to Quincy in satisfaction of a debt. This agreement does not fall within the statute of frauds, so it does not need to be in writing to be enforceable. Note that this is not a guarantee to pay the debts of another because buyer did not agree to answer for seller's debt to Quincy if unpaid. So as a result, neither 1 nor 2 would be viable options here. You're almost at that finish line. Question number 10. Airco operates an aircraft maintenance and repair business serving the needs of owners of private airplanes. Flyer contracted with Airco to replace the engine in his plane with a more powerful engine of foreign manufacturer. Airco purchased the replacement engine through a representative of the manufacturer and installed it in Flyer's plane. A short time after it was put into use, the new engine failed and the plane crashed into a warehouse owned by Landers, destroying the warehouse and its contents. Airco was guilty of no negligence in the procurement, inspection, or installation of the engine. The failure of the engine was caused by a defect that would not be disclosed by inspection and testing procedures available to an installer. There was no negligence on the part of Flyer, who escaped the disabled plane by parachute. Landers recovered a judgment for damages from Flyer for the destruction of his warehouse and its contents. And Flyer has asserted a claim against Airco to recover compensation on account of that liability. In that action, Flyer will recover A, full compensation because the engine was defective, B, no compensation because Airco was not negligent, C, contribution only because Airco and Flyer were equally as innocent, or D, no compensation because Landers' judgment established Flyer's responsibility to Landers. Take a few seconds, choose the best answer. Best answer here is A, full compensation because the engine was defective. Remember that products liability is strict liability for defective products. Remember, there are other theories of product liability, but strict liability is the easiest for a plaintiff to prove. The general rule is that a seller of a product is strictly liable for injuries caused by the defective products that they sell. Strict liability applies not only to the manufacturer, but also to any other merchants in the distribution chain. A merchant is a seller who routinely deals in the goods at issue. In this case, the facts establish that the plane engine was defective. Airco is a merchant in the distribution chain. of this plane engine because it operates an aircraft maintenance and repair business, so it routinely deals in plane engines. As a merchant in the distribution chain of the plane engine, Airco can be held strictly liable for the defective plane engine. Therefore, Flyer will recover full compensation because the engine was defective. Now, in analyzing our other option, no compensation because Airco was not negligent. Remember, negligence is not necessary, just simply a defective product. C, contribution only because Airco and Flyer were equally as innocent. Irrelevant, damaged product, defective product. That's what we're looking at. D, no compensation because Lander's judgment established Flyer's responsibility to Lander's. Again, irrelevant. We're looking at a defective product at market. Liability exists. That being said, A should be the very best and only option that you should have chosen. As always, thank you for joining us on Bar 10, where it's our goal to help you prepare for this bar exam 10 questions at a time. I hope you enjoyed the content. If you did, don't forget to like, subscribe, and click the notification bell so you can be updated every time we upload new content.